Hey everyone, welcome to another episode of DarshanTalks. I am your host, Darshan Kulkarni. As you guys know, I'm an attorney, I'm a pharmacist, and I advise companies with FDA-regulated products. So if you work in or have an interest in FDA-regulated products or their companies, this is the podcast for you. Today's podcast, we are going to talk about privacy at a global level and maybe at a state level if we have enough time. And if you are either a privacy officer, if you are an individual who works like a CEO, a C-suite person, if you're working in clinical research, if you're working in marketing in a life sciences company, you're going to care about the conversation today. So our guest today is leads Beckage's global privacy team, where she represents clients in cross-border data management. She helps create cost-effective and business-oriented approaches to cybersecurity, data privacy, and technology compliance. I'm going to admit that sounds really impressive. She has been recognized as a super lawyer's rising star for technology law. She practices in many jurisdictions across the U.S. I usually just say two. When she says many, I have to believe that's more than two, which is just impressive. I'm not sure I want to sit for any more bars. In both state and federal courts, as well as internationally in both Europe and Asia. She's currently a lecturer at UC Berkeley and assistant teaching professor of law at Drexel University Thomas Klein School of Law, where she teaches on data privacy and cybersecurity. I just heard from her that she's also helping write something with Seton Hall, and she is helping at a university in Ireland as well. Mm-hmm. I'm running out of breath, but I haven't run out of things she does. So I'm really excited for today's guest. Ladies and gentlemen, our guest for today, Jordan Fisher. Hey, Jordan, how are you?
Hey, it's great to be on. Thanks for having me.
Thanks for coming on.
It's always hard to sit here and listen to all the things that you've done and you go, oh, yes, I forgot about that.
Well, it's fun when you had a fun time doing it, and then you get to actually go, yeah, I did do that. Wasn't that cool? That was fun. Inevitably, at least in my case, I kind of go, yeah, I'm kind of over it. I want something new to go after. And what's the latest challenge I can go into? So it's funny when the latest challenges, because today's podcast, when I came into it, I was going to talk about a bunch of different things. And you told me that you're dealing with quote unquote Schrems 2. So do you want to talk a little bit about what that is, why it matters, and why should a life sciences company, say, for example, working with clinical trials, care?
Right. And so this is actually really interesting in the life sciences space, because a lot of my clients that sit sort of in that ecosystem, you're used to dealing with sensitive data. You're used to dealing with clinical trial data, research data, et cetera. But oftentimes you're dealing with not necessarily the direct patient data, but sort of a subset of that data. There's been some derivatives removed from it, the personalization has been removed from it, et cetera. So there's sort of this belief that you sort of fall outside of some of these more general privacy regulations because you're so regulated in sort of the clinical trial space of what you're doing. And so I think it's a shock for a lot of them when we sort of sit down and we start saying, well, actually, you might fall into the GDPR or the other sort of general privacy regulations, because is that truly anonymized data or is it pseudonymized, which pseudonymized would fall under the GDPR, anonymized would truly fall out of it. And then you really delve into it and there's sort of some more nuances to be aware of. So I think, when looking at Schrems 2, you first question you need to ask yourself, if it matters to you, is, am I collecting data from the European Union? And if I am, I've got to do some GDPR analysis, because I have to understand, is the GDPR going to impact my data? But sort of putting the GDPR not to the side, but sort of the global question of, am I impacted by it? Why did Schrems 2 matter? And sort of how did we get here? So a continual point of tension. Yeah.
Before you continue, I think we need to draw that distinction, because it's such an important distinction that point you're calling out, which is anonymized versus pseudo-anonymized. What is the difference? Why does it matter?
Yeah, and so in full disclosure, I've done a lot of research in this space on my academic side, and we'll have some forthcoming sort of guidance that I'll be able to share, hopefully, when it gets published. But this is a very interesting area. What is personal information, personal data, and what is not personal information and personal data? And the challenge in this space is that we use these terms pseudonymization, de-identification, anonymization, aggregation, to really all sort of mean varying different things when it comes to removing identifiers from information. And the added complexity is that not all of the laws define those terms equally. So comparing, say, the Japanese Data Privacy Act to the GDPR to the CCPA, they all use various different terms, define them differently, but they're all sort of getting at this idea of data that can't be used to identify the individual. So it's really important that you sit down with someone who's fairly knowledgeable on the legal side to understand, okay, in GDPR, anonymization has 3 factors that the European Data Protection Board has laid out. And if you can't meet those 3 factors, then you're not going to have anonymized data. We have to define it differently. But at the same time, there needs to be the technical side sitting down in that same conversation, because the law is going to tell you we have to be able to demonstrate X, Y, or Z. And the technical group is going to be able to tell you, this is actually what we're doing to the data. This is how we're manipulating it. This is how we're removing the data. We can't re-identify it. The statistical likelihood of re-identifying it so low that the risk isn't there. So it is a really good distinction that you call out, because I find a lot of companies assume their data is anonymized, but they haven't necessarily done the due diligence to really look at the legal definition of anonymization, look at how they're technically addressing anonymization and ensuring that they match together. So that's an area that I think is really confusing, because the law is a bit all over the place, and the technology, candidly, is also a little bit all over the place, because I don't even think there's necessarily a true sort of industry standard when it comes to anonymization techniques, pseudonymization techniques, de-identification, blah, 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 all those terminologies. So it's a good distinction to call out, and it's something that I think, especially in the life sciences, because you are dealing with what I would say, you have personal data, you have non-personal data, and then there's like this really gray area in between that life sciences sits in at varying levels. And what you need to do is figure out for each data set, like, what am I actually getting?
And I think it's important not just in the live studies you're doing, it's also important when you're talking about things like transparency. There's a whole element, and I don't know, Jordan, if you get involved in this at all, but I do. And it's basically this area where the EMA, which is the European version of the FDA, comes out and goes, we want you to disclose everything. Those applications you made to us, we're going to disclose everything. So you can pull out the things that are considered to be either confidential business information or information that should be de-identified, anonymized, or pseudo-anonymized. And you have to make an argument for that. But to your point, that process has already started, and it's hugely complicated. So talking to someone like Jordan is often a great idea. Talking to the lawyer that's right for you is often critical. But sorry, I didn't mean to cut you off. So you draw that distinction. You talk about,
yes,
connect that a little bit further for me into Schrems.
Yeah, and I will say, just as a side note, I clerked on the European Court of Justice, which is the highest court within the EU system, and I actually handled some of the EMA transparency cases while I was a clerk on that court. So I'm heavily aware of sort of that component, and that was actually my introduction to data privacy and transparency, was through the EU courts and looking at sort of the EMA decisions and the requirements and comparing them to the FDA, because we sort of were looking to comparative sort of framework. So like really interesting. I happen to be more well-versed in that than you probably would have assumed. But so to talk a little bit more about Schrems too, what was so impactful is, and this is a continual tension between the EU and the US, is transferring personal data from the European Union, where privacy is a fundamental right, to the United States, where we do not have an omnibus federal privacy law. And there are concerns, especially in light of things like the Snowden leaks and some other sort of changes in the US surveillance law, where the EU has consistently challenged and questioned whether EU personal data that is transferred to the United States is truly being provided sort of the GDPR protections as they would require under their law. So what we had was in Schrems 1, the safe harbor provision, which was the agreement between the EU and the US to transfer data internationally, was invalidated. So very quickly thereafter, we had the EU's privacy shield be adopted between the EU and the United States. And in July of 2020, so last summer, the EU court again invalidated the EU's privacy shield, and really on very similar terms as they invalidated in Schrems 1, the safe harbor provision. And basically, there was this huge concern around the use of US surveillance laws by intelligence agencies to access personal data when it would be transferred to the United States. And they really highlighted a few concerns specifically with that. One is whether or not the individuals would even know that their data was going to be visible to public agencies, knowing so that they could then maybe refute that or sort of use legal process to get some redress. And two is whether or not there was any capability of the companies to prevent that action from being taken. We have these sort of cables that run under the Atlantic, for those of you that aren't aware of it. And there are some capabilities of the intelligence agencies to sort of capture data before it even were to hit some of the company's servers. And so that capability really scares the EU government, especially when it comes to ensuring that there's privacy protections. So Schrems 2 invalidated the EU's privacy shield, which some of you might have self-certified under, although it was still quite new. So we did not have sort of a large proportion of private entities that had self-certified under that mechanism. But what was frankly more impactful was that the EU court upheld the continued use of standard contractual clauses, which were a contractual mechanism to import data into the United States. But what it said was that in certain instances, a la sending data to the United States, the companies may need to implement supplementary measures to ensure that the same or adequate level of protection is being provided to that data when it comes to the United States. So why does this all matter to life sciences? Why does this matter to private industry? The real challenge is that it really puts the onus and the burden and the obligation on the companies to confirm that what they're doing is really going to comply with EU law. So the court sort of left open what are those supplementary measures that would be appropriate, and then made very clear that we're not going to tell you what those measures are, but we're going to require you to figure it out, to do it, and to sort of do the assessment and do the analysis. So it really puts a lot of burden on companies, and we've really been seeing a lot of things like security questionnaires that are saying, how are you addressing surveillance laws within the United States? Are you taking supplementary measures? If you were to be requested by a public agency to have access to data, what are the steps that you would take, et cetera, which is really sort of requiring all US companies to do this deep due diligence on US surveillance laws, which if you had asked us a couple of years ago if we as private entities would be doing that due diligence, I don't know if many of us would have sort of gone down that path. So the question starts with, do I have personal data? And then it bleeds into, if I have personal data, how am I going to ensure that that data is being provided adequate protection if and when it comes to the United States? So that's like a big area that I have seen impacting sort of global data transfers, global data privacy, and it's impacting businesses across all industries, all sizes. It really comes down to, do I have personal data under the GDPR? And if you do, you need to do a Schrems analysis.
So you talk about the Schrems analysis and how that sort of is changing how companies who are not even in the EU have to deal with basically figuring out how to deal with data coming across EU borders. A recent country that has to deal with that is the UK. And
yes.
for lack of a better term, and this is a technical term, but I believe in lawyerese we call it a shit show. So
yes, that is the accurate term. Although less of a shit show this week than it was last week, to be honest. So.
Exactly right. So can you talk to us about what happened to ease the shit show, if you will?
Yeah, so Brexit is what we're all alluding to. And Brexit occurred on the end of December of 2020. And what we didn't know was what was going to happen as to data transfers, because December 1st of 2020, the UK was within the European Union, and therefore data could be transferred between the UK and other EU member states without having to go through sort of these additional requirements, standard contractual clauses, et cetera, et cetera. January 1st, we're outside of the EU. So the UK really had to reassess and renegotiate the way in which these data transfers were going to happen. Now, there was like a 3 to 4 month time period where they said, we're going to allow data transfers to continue in the hope that we'll negotiate some type of agreement. And so what we had last week was that the EU announced a draft UK adequacy decision. And so in essence, an adequacy decision is whereby the EU makes a determination that the third country, i.e. the UK, provides an adequate level of protection for personal data that's transferred to it. Now, this is not a surprise because the UK, as part of the EU at the time that the GDPR was passed, had to wholesale adopt the GDPR within its national legislation. So we have the UK Data Protection Act of 2018, which really is the GDPR in UK. So as we currently stand right now, there is an adequate level of protection. There's almost the same level of protection. You know, the UK was under the EU Court of Justice's decision, so it had to comply with those. It hadn't sought any deviations or anything like that. And in fact, the UK's Data Protection Authority was one of the more robust data protection authorities out there, sort of pushing GDPR protections. So as it stands right now, it looks like we're going to get a breath of relief and basically be able to continue to transfer data between the UK and the EU. Two things to note, though, that I think are really important, sort of forward thinking. One is the UK to the US is a completely separate question, right? This is dealing with EU to the UK and back and forth. This has nothing to do with the United States. So if you are using the UK as a hub, which many life science companies based out of the United States have a significant presence within the UK, you're going to still have to deal with how we transfer data from the UK to the US. And by the way, the UK might deviate from Schrems too, because now they're actually not under that obligation. So you've got to really be watching how the UK is interpreting international data transfers, because it might deviate. Now, currently, we don't see any indication of that, but it might deviate now or in the future from sort of that Schrems 2 dialogue. The second point is that, yes, the UK, as we currently stand right now, is very aligned with the EU data protection regime. But as the years progress, the UK could certainly deviate from that, not in ways that might lower the protections, but might make more challenges from a business perspective, because they're not necessarily going to have to follow the GDPR. They're not necessarily going to have to follow the court decisions that come out of the EU courts related to GDPR. So it's important that you recognize that, yes, while the UK currently is very aligned, it's now another jurisdiction that we've got to be following as it relates to data transfers. So the complexity is slightly less because of the adequacy decision, but we still got to deal with it. There's got to be sort of a Brexit strategy and a strategy going forward of how you're going to handle the fact that these are now two distinctly separate regions and they could deviate from each other in how they treat privacy.
Which raises the question, how often can countries challenge the adequacy decision going forward? In the sense that the UK is fine right now, in 5 years, there could be a bunch of different decisions which might make it veer off. So would someone challenge it at that point? And in the same way, could the US sort of go back and forth and therefore get challenged by itself as well?
Yeah, so the short answer is that the way that these adequacy decisions work, both within the GDPR text and then within both adequacy decisions, like the actual text of the decision itself, they require the EU Commission to conduct regular due diligence to determine if that adequacy decision remains valid. So the EU Commission itself, which is one of the agencies within the EU legal system, will be reviewing, revising, taking a look at those decisions. Now, most likely what would happen is something similar to Schrems 2, which is where an individual challenged the standard contractual clauses and sort of components of the EU-US Privacy Shield, and the individual brought it to the attention of the European courts, which ultimately held it to be invalid. There's nothing that would restrict, though, a member state themselves from doing that same type of lawsuit, sort of questioning the validity of that adequacy decision. So the short answer is that it is certainly something that probably will be monitored very closely, more closely for the US than the UK, because the US, even though the UK is outside of the GDPR system, it has an omnibus privacy law. The US does not. And so it's just in a more tenuous position vis-a-vis the EU sort of approach to privacy. So probably any agreement that's going to be put in place between the EU and the US is going to be more monitored closely. And frankly, the other reason is because a lot of big tech stores their data in the United States. So it's a hub for data. And so it's just going to have that much more of a critical eyesight on sort of what is happening within the United States. But anyone could challenge any of these sort of decisions, which is, you know, a lawyer's dream or nightmare. I don't know. It depends on how you're looking. Looks like we might have lost Darshan.
Sorry, I assumed that I was on screen when I said that. Carmela actually came on and she asked if there was any implication of Brexit. And turns out there was. And then she went, oh, okay, there it is. So I do want to say thank Carmela for writing in. I do want to take that next step, though. So we've sort of covered what Schrems 2 is. We've covered the adequacy decision. But let's talk a little bit more about how this implicates the U.S. And when I say this, I mean the concept of the lack of an omnibus bill, the lack of consistency. Before I jump into that, though, just out of curiosity, what countries, if any, do have outside the UK have an adequacy decision?
So there's actually a number of countries that have an adequacy decision. A lot of them were pre-GDPR, but they apply post-GDPR. So, as a bit of a primer, the EU had the data protection directive starting in 1995. And under that mechanism, a number of countries received an adequacy decision. Those adequacy decisions still apply post-GDPR. They are, of course, subject to review and revision, et cetera, as we sort of see the EU changes. The first country to have received an adequacy decision post-GDPR was actually Japan. So Japan has a pretty robust data privacy regulation in place. I think a lot of people tend to focus a lot on Europe, but if you actually get into the Asian region, where I do a fair amount of work, there's more data privacy regulations than you're probably aware of. I mean, frankly, China has a data privacy regulation and a cybersecurity regulation. Japan, South Korea, Australia, New Zealand, all of these regions have these omnibus data privacy requirements. They have a little bit of a different flavor sometimes. They're maybe not as robust. They might be carved out to certain industries or size of business. Australia's has sort of some of those nuances to it, but they do exist. But so Japan was the first post-GDPR adequacy decision. The adequacy decisions have been pretty slow. Part of that is because the GDPR went into effect in 2018. We have them sort of building up these stronger supervisory authorities at the member state level. And then frankly, in 2020, all of us were distracted. So they have been a bit slow, and we've seen them prioritize things like the UK over maybe some other countries that are still waiting to hear if their adequacy decisions are going to be met. We have a couple of countries that are relevant to just be aware of. Canada, probably for the US being the most significant, because Canada has PIPEDA, which is their omnibus privacy law. It's a little bit different in Canada because of the provinces. So each province is allowed to have its own privacy law as long as it sort of meets the floor of PIPEDA. But what they're doing is, and they were planning to do this in 2020, we expect it to actually occur in 2021, is they're updating that law to more align with the GDPR and therefore seek an adequacy decision. So what that means is a lot of our companies do business in the United States and Canada. So GDPR is just getting that much closer as we sit here, because Canada is a huge market for us. It's a sister country right there, and especially in the pharmaceutical industry, it's very common for the U.S. operations to serve both the U.S. and Canada out of the same offices.
So thank you for sort of catching us up there. Let's talk a little bit about the U.S. at this point. And I know I thought we'd get done in 15, 20 minutes, but this is far too interesting, so sorry.
I love talking about this stuff, so.
This is super fun. We don't have an omnibus bill, but what we do have is different states with their own unique ideas of what privacy should look like. One of our favorite ones that's coming up, well, everyone's favorite is obviously CCPA and CPRA, but let's talk about the changes in people are talking about biometric laws, and of that, obviously New York being one of them. Could you talk a little bit about this new swing of interest in biometric laws, and what does that mean? What states generally are implicated, and how does that play itself out?
Yeah, so you sort of highlighted something that's the uniqueness of US law, which is that we're very willing to sort of look at privacy in discrete industries or with discrete sets of types of data. When we start talking about sort of a general privacy law, we've sort of been very skittish about that. Part of that is because unlike the EU, we don't really have this foundational concept of privacy. We have the Fourth Amendment, which really deals with privacy vis-a-vis the government. And frankly, we've had a privacy bill the Privacy Act of 1974 that restricts government collection of our information, which if you look at it, very, very similar to the GDPR. So I just want to point that out. In 74, we were sort of on this path. But when it comes to private sector collection of data, that's where we're a bit more skittish in the United States. So what we're seeing is states, like you said, sort of tackle this in different ways. We have the CCPA approach, which is one that's sort of being adopted by a number of states. I think Virginia, Oklahoma, Florida are the current ones that are like in everybody's inbox this week. But then we have a lot of states that are saying, we're not necessarily going to get the buy-in for a general privacy law, but we can all agree that there are certain sensitive data out there that we need to protect, right? This is like the healthcare argument. Like nobody really fights healthcare privacy. We have to figure out how to deal with HIPAA. And so one of those is biometrics. And the reason being that, biometrics tend to be inherent to who you are. Last time I checked, you can't get a new face. So if you're using my face to gain access into systems, that's going to be a problem if you steal my facial recognition, right? That's going to be an issue. So we sort of have this buy-in at a number of states saying we feel very confident that biometrics is something that we should regulate. Now, Illinois has led the charge in the United States and is a very aggressive enforcer of its Biometric Information Privacy Act, or BIPA. We've actually seen a number of lawsuits get filed that have some very, very high settlement amounts or fines or damages that come out of it. I think in general, we have this consensus that's using biometrics without consent, using biometrics in a way that we wouldn't necessarily have anticipated is very damaging to the individual. Because again, I can't go out and get a new face like I could get a new social security number or, other identifiers that might be easily changeable. So Illinois has really set the scene for biometrics, but then we have states like New York that have recently put forth biometric data privacy laws very analogous to the Illinois. And what they often require is things like consents, deletion of the data after a period of time, being transparent as to how you're processing that data, if you're using third parties, how those third parties are gaining access to that information. And what's a little bit different about the New York law is that it has heightened fines per violation. So it's really upping the ante for companies when it comes to biometrics. And for most companies, biometrics are really going to come into play with employees. So we see this more and more, using a thumbprint to scan into a building, using an eye scanner, using facial recognition technology to get into systems that we find are really sensitive, or sort of this cool technology that we want to use. And that's what we're seeing in Illinois, is that a lot of the lawsuits, it's not necessarily consumer driven, it's driven by your employees. And guess what? They have a private right of action. So I can bring a lawsuit quite easily in those jurisdictions because I can basically claim, a BIPA private right of action. I'm going to get past a motion to dismiss, and then we're going to go into a full-blown lawsuit. So we anticipate sort of that same trajectory within New York. Once that law is passed, there are going to be proactive requirements on businesses if they're collecting biometrics. And I would highlight too, so many businesses will say, I don't collect biometrics. And then I'll look into it and I'll say, okay, do you use a third-party vendor to collect it? And they'll say, oh yeah, of course I use a third-party vendor. Well, guess what? That's you collecting it, because you're going to have obligations and responsibilities for any third party that you bring into sort of this data transaction. So it's really important that you sort of really sit down with your team and say, are we collecting biometrics? Is that from employees? Are we collecting them from consumers? Are we doing anything funky or weird with those biometrics? It's really important to stay on top of that. And I'll add one point to this, because we are seeing this mostly at the state level, but the FTC, the Federal Trade Commission, which does a lot of privacy and security enforcement at the United States, across the US at the federal level, they just had a case where they had a consent decree against EverAlbum, which is it was a platform that collected photographs. And it's an interesting case. It's talking about facial recognition technology. And in essence, there wasn't the appropriate consent, and the privacy policy wasn't clear enough, et cetera. So if you're doing anything in facial recognition technology, you've got to take a look at that case, because that's going to tell you what the FTC thinks needs to be in those privacy policies. But what was really interesting about that case, and I think is actually the more impactful part of that case, is that they required that EverAlbum not only delete the data that they had collected, but delete the models they had built off of that data. That is literally deleting your business assets, because the models are what is valuable. Like, yes, your face is valuable to train the model, but once I've trained it, your face is no longer valuable to me, right? I'm deleting that data is like, okay, that's fine. But because they built it off of data that they never should have had access to or didn't appropriately obtain access to it, They made them delete those models. And that is a business asset, that's IP. There's a lot of consequences for a business. So it's really important that you get the appropriate consents, acknowledgements, et cetera, from the start. Because if not, everything that comes from that might end up being an asset that has to be destroyed.
So that really brings the question in the life sciences. For example, what if you are using someone's biometrics to diagnose a disease or to diagnose vital signs of some kind? Would that, therefore, the trading process would technically be covered under laws like these biometric data laws? And therefore, theoretically, if you're forced to delete that data, you may not be able to get FDA approval because the FDA would say, I can't look at your source data at that point. So that would become hugely problematic.
That could be very hugely problematic. And that's why I just want to emphasize, like, a lot of times, you have so many parties working in the life sciences. Somebody's running the clinical trial, somebody's actually running the diagnostics on the data, somebody else is actually submitting the application, right? There's like many hands in this pot. But it's really important that you understand, okay, I'm going to sit in this point. Do I have obligations on consents? Or am I going to make sure that everyone who gives me data is going to confirm they have that consent? Because you don't want to get into a position where you get bad data and you have some liability in light of that bad data. You really want to make sure, and this is where it comes down to having the appropriate contracts in place, establishing what your data relationship is, not your other relationship, right? That's different. This is your data relationship. Where do I sit in the data transaction, and what are my obligations flowing each direction, right? Because it's all over the place in life sciences about who you're going to be working with, the platforms, et cetera. So I just want to highlight, because life sciences is a bit more of a matrix when it comes to how the services are provided.
Which really raises the question, just to clarify the biometrics, and then I have one last topic to get into. But is DNA considered part of that biometrics in general? Obviously, each state will differ, each analysis will differ. But do you see DNA, for example, I'm specifically thinking of something like the Henrietta Lacks case. I don't know if you've read the book or anything like that, but her DNA was used to use for different things.
Right.
Would that be considered to be her ownership under these biometric data laws?
So the biometric data laws aren't necessarily around ownership, like we sort of see in the EU context. It's really around transparency and getting appropriate consents. So the short answer is it's not clear. It's really not clear. Part of it is because it's only a couple of states that have a law like this, and Illinois is the most aggressive in pushing it out. So the way the laws are drafted, like little tweaks here and there, might substantially change that analysis. But a lot of the laws are not necessarily, like the biometrics around ensuring you got appropriate consent to use that data, not necessarily around sort of who owns that data and who owns the IP that's derived from that data. I think the challenge we have with DNA is that it's inherently personal, right? So like, I understand that like you might be able to not identify it unless you have the appropriate codes or all of the information, but you could still identify it, right? There's still a capability to identify it. So, sometimes it's expressly carved into biometrics. Sometimes it's not expressly carved in, but you can make a strong argument that it is. And I think that, making sure that you understand when it needs to be addressed, and sort of, again, it's going back to, did you get good data from the get-go? Because if they're giving it to you for research purposes, there's a strong argument that they should have understood it's going to be used for research purposes in a global sense, right? So it's really going back to the drawing board of how are we getting this data? Are we providing the appropriate consents to make sure that you have good data now and in 10, 20, 30 years? So but the Henrietta Lacks case, putting that in today's world is a there's so many components to that story. And I highly recommend reading the book if listeners have not read it. It was very good. But the data privacy component, I think, is something not necessarily highlighted in the book, but would be really interesting to explore in sort of a 2020 and beyond world.
So maybe we'll have you back and we'll have that discussion.
Yeah.
So let's ask one last question that I'm kind of curious about. I've seen very little discussion about the proposed HIPAA updates and the balance they're drawing compared to, say, GDPR. Have you had a chance to look at the updates? If so, what has been your thoughts around it compared to, and how it implicates life sciences compared to, say, GDPR?
Yeah, so I haven't delved deeply. We have a fantastic HIPAA group who I get to just field all of my questions to. So I will put that caveat on top of here. But what I always sort of draw a distinction with when it comes to HIPAA versus GDPR is HIPAA is a very narrow law in the sense that it is not as broadly applicable as GDPR. It's a lot of transparency and consent, but not necessarily sort of like the down the line the down the line rights, et cetera, that you have in GDPR. Like there are some rights in the HIPAA context, but a lot of times it's just making sure we're treating you and we're going to share this data as part of that treatment. It's really like being that transparency component. I do think that HIPAA is attempting to update to more reflect sort of the sharing of data and the fact that we now have 4 or 5 different electronic health records players that are really prominent in the market. So that means there's a consolidation on the back end of our data, and also recognizing that we all move around. In a pre-COVID time, we moved around significantly. So the odds that you might be treated in multiple different jurisdictions, in multiple different systems is pretty high. So from my perspective on a general sense, and again, I'm not going to get into the detail because like I said, I leave HIPAA to those amazing folks at Beckage who deal with HIPAA. But I think they're trying to update themselves and sort of come more into where we see healthcare going. The other thing that I think is going to be really interesting to watch from a HIPAA context is the telemedicine components and the way in which we're using technology now in this space. And I think that relates to the life sciences in the sense that there's some pretty cool things that we might be able to track that we couldn't track before, because we're using telemedicine, because we're using things like taking your diagnostics daily, whereas maybe normally you'd only come in 3 times a week to get those diagnostics because now you have the tools at home. Or even tracking things like, are you in fact taking a 1 mile walk, and where's your geolocation on that 1 mile walk? And can we sort of track that, which I think it's somewhat relevant in the treatment context, but it's really interesting from a life sciences context if we can start to gather all this data and really do analytics on it and truly understand. So I think it exposes some larger data sets that we could maybe look at. But again, it goes back to, are we doing the transparency initiatives? Are we getting that data appropriately? And what are the privacy concerns with that data, and making sure we understand that?
So, Jordan, I usually end this with a short 5 rapid fire questions. Are you ready?
Okay. Yes.
Okay. What is an accomplishment you're most proud of?
I would say building a business. I'm very proud of that. Building a business that I'm very proud of, and that I think truly adds value to companies.
Very cool. Who is your hero or heroine, and why?
Oh, this is a hard one. So I would have to say, it's like my family, but like, I know you probably want one person, but I will say it's looking at my family. I have a very long family of entrepreneurs. And I myself am an entrepreneur. I had started my own firm, and then I, joined Beckage, and I really embraced sort of being with that team. And I think, I'm able to do that because I have a very amazing family who sort of paved the path of it's okay to take the left versus the right when everybody in society takes the right. So I would say those are my heroes, because they really support me and give me that foundation to sort of do all this amazing work that I get to do.
Very cool. What is your favorite way to give back to your community?
Talking to people. And I'll explain what I mean by that. So I have an amazing community. And when I sort of went out on a branch and started a practice in this area and built a business in this area, so many of those community members got on a phone with me and just gave me their perspective. They made introductions for me. They continue to be this incredible source of just support as I continue to grow my own presence in that space. And I truly believe that the only way you can give back to those people is by turning around and sort of lifting up the people behind you. And so I really try to take every phone call I possibly can. I will talk to anybody about my own journey. I talk to a lot of my students. I just want to be a support system, because that system was so valuable to getting me to where I am today.
I agree. How do you define success?
I think success is having fun every day and enjoying what you're doing. And I am truly blessed to have at a very early part of my career been able to find a space that I love talking about. I mean, I do it all day, every day. I love talking to students about it. I love talking to clients. I get to do really fun projects. And I think that's it. If you're having fun, if you're laughing, if you're at the end of the day, you're going, I could do another data privacy talk, then I think you're in the right spot.
Last question. What challenges you?
I think saying no. I think that is the hardest thing for me. Is I love everything. I'm a bit of a jack of all trades. I mean, anything from I love skiing, I love playing sports, I like reading, I like teaching, I like writing books, I like speaking, I like being on TV, I love being with clients. If you name it, I'm a yes person. That is my personality. I really try to embrace everything. But I think that can also be a detriment because then you can overstretch yourself, et cetera. So what challenges me is saying the word no.
Very cool. So again, Jordan, thank you so much for coming on. Based on our discussion, what's one question you'd like the audience to answer for us in the comments?
I guess it would be, where do you see data privacy law impacting you the most in your day-to-day work? I'd be very curious to hear that. Mm-hmm.
Very cool. Okay, so during this conversation, we landed up discussing the Schrems decision, Schrems 2, and actually Schrems 1 as well. We then talked about the EU Privacy Shield. We talked about US surveillance law, interestingly enough. We talked about the Brexit adequacy decision. We then went into the different state laws. We talked about things like the New York biometric law, but also BIPA and Virginia, Oklahoma, Florida. We talked about HIPAA as well. And I loved how you ended it when we started it early on, where you actually said, in 12 to 18 months, we're going to look like a very different nation from a data privacy perspective. So thank you again for coming on. Quick question for you. Where can people find you if they want to hear more about you or hear more about the kinds of discussions you have?
Yeah, so the easiest place is to go to beckage.com. You can see there all the different places I'm speaking at. You can see my bio. You can also learn more about our firm, and you can actually follow the blog, which is a great resource to keeping up to date in this space. We really try to provide a lot of useful content to our clients and to our community. I'm also on LinkedIn, so please connect with me there. I'm on Twitter, where I get to talk a lot about sort of some technical issues and really try to promote my research. So those are probably the best places. And I encourage everyone to reach out. I'm more than excited to talk with you. I love talking to people. That's what Darshan and I were talking about, how hearing people's stories is just really fun. So please reach out and stay in touch.
Thank you again. And if you like this podcast, please leave a comment, answer the question that Jordan had. Please subscribe. You can find me on Twitter at DarshanTalks or at my website at DarshanTalks.com. And thank you again, Jordan. Thank you for coming on. Love to have you on again if you don't mind.
Yes, would love to come back.